Hello friends, welcome. Friends, this whole issue about adjusted gross revenue has become a bone of contention for all the stakeholders in the industry, including the regulator and the courts. Now friends, Vodafone Idea especially is now in a very stalemate kind of situation. Why? Because on 31st March 2026, there is a due on Vodafone Idea on account of pending AGR of 18,000 crores as installment. And if they don't pay, then they will go out of business and they don't have enough cash EBITDA to make that payment. And therefore, it is extremely important for Vodafone Idea to resolve this problem before that date. And DOT is also trying their level best to somehow able to reconcile the situation so as to allow Vodafone Idea to continue. But DOT is unable to do that because of the earlier Supreme Court judgment of 2020, where a principal levy on Vodafone Idea of 58,000 crores was imposed of pending AGR due on account of a legal battle which lasted for 20 years. And that amount has now exploded to 83,000 crores as principal outstanding, and they have to pay in 6 installment, which is the last date is 31st March 2031. Now friends, why I am doing this video? The reason I am doing this video is that if you recall, DOT and Vodafone Idea were trying to resolve this problem for a long period of time. DOT took share in Vodafone Idea to the tune of 49%. But on the AGR issue, they have been a stalemate on account of the 2020 judgment. Vodafone Idea filed so many petitions before Supreme Court, but they did not get in respite. Curative petition, review petition, they got respite. But in this month, they got another opportunity to make petition before the Supreme Court on account of a DOT demand of 9,450 crores on top of the earlier demand, which was finalized in Supreme Court on 2020. So Vodafone Idea filed a petition, and then 2 hearings took place. Now, yesterday, there was a news that Vodafone Idea has filed an amendment to the petition, which they filed earlier this month, saying that now interest and penalties on the AGR dues decided by the Supreme Court in year 2020 should also be waived off. Now, this video is to understand this complexity and the nuances, because this is too confusing to the viewers who have been watching Vodafone Idea making so many applications in Supreme Court and failing. And they also have requested Supreme Court and DOT both to waive interest and penalty, but they were not successful yet. So what makes us think that they will be successful this time? This video is all about that and what options Supreme Court has before them, given that so many opportunities of correcting the past mistakes were lost. Curative petition, review petition, and then multiple other petitions which Vodafone Idea has filed all got rejected. So friends, this is the title of my presentation, Vodafone Idea's new AGR petition. Actually, it is not a new AGR petition. It is an amendment to the section of prayers of the earlier petition which they filed due to the DOT's 9,450 crores of additional demand. So now, what Supreme Court will do and how the Supreme Court is going to decide this case is all that we are going to talk about in this presentation. So why this matters? What is the importance of this issue right now? This matters because VI is seeking relief of interest and penalties, because this is pretty strange. See, interest and penalty issue was decided by the Supreme Court in 2019, and Supreme Court said that the operators knew that the payment of license fee has to be made on the total revenue because of the unconditional acceptance of the migration package, which talks about total revenue. Still, they did not pay, and therefore they have to pay interest and penalties also on the demand which they decided on 2020. Now, the problem here is, friends, that the demand which got decided in year 2020 by Supreme Court is based on DOT's preliminary assessment. This is the point, because when DOT filed a modification application on what was the date on 16th March 2020, which is annexure A5, in this modification application, the first thing is to note is preliminary assessment and the caveats which DOT has put, which said that dues are subject to further revision due to departmental assessment, CAG audit, special audit, court cases, etc., which clearly points to the fact that this demand, which was shown in the table for Vodafone Idea, which is to the tune of 58,000 something crores, 248 crores, is not the final amount. Now, what Supreme Court did? Supreme Court disregarded this DOT's preliminary assessment and the view that DOT took that this is not the final amount and said that nothing doing, this is going to be the final amount. So they disregarded the caveat of DOT, which said that all dues are subject to further revision due to departmental assessment, CAG audit, special audit, court cases, etc. Which means that Supreme Court now if DOT can, now the point here is that when DOT filed this, they actually mapped their claim against this caveat. This is the caveat on which they mapped their claim. Now, the problem here is that if DOT can revise, the natural justice demand that VI should also be allowed to correct errors, right? Because Supreme Court said that, look, whatever DOT has given, the preliminary assessment is the final table, which you have to pay because you guys have been trying to wriggle your case around and saying that to get away because you've been fighting for 20 years and you just don't want to pay. You corporates, you make so much amount of profit, you are not allowed. I will not allow you to get around this case and therefore you have to pay and therefore that preliminary assessment became final. Now, if DOT can change the preliminary assessment and make new demands and make modification into the earlier decided number by Supreme Court, why can't VI be also allowed to do that when VI clearly claimed that the DOT's calculations were incorrect and there have been a lot of double counting and errors? Now, Supreme Court now faces a clash between precedent finality and complete justice because neither Supreme Court can give DOT an opportunity to correct their demand, nor it can give VI an opportunity to open and make the self-assessment, reassessment, and reduce that earlier demand which Supreme Court in 2020 finalized because it would tantamount to opening the 2020 case. Now you can understand the difficulty the Supreme Court is in. The AGR litigation, the timeline. Now it is important to understand the context in which this whole discussion is happening. The context is pretty simple. In 2015, TDSAT finally, after back and forth between Supreme Court, which I have already spoken about in my earlier video, gave a decision in favor of the operators. So that they said that, look, operators are not supposed to pay license fee on the total revenue, but only in the subsection which belongs to the telecom portion on which they need license. Non-telecom, they don't want to pay. But Supreme Court, what happened was they, in 2019, undo the TDSAT case and said that TDSAT has committed an error and operator has to pay license fee on the total revenue. And the demand was finalized in 2020 and DOT now made an additional demand of 9,450 crores recently, which was challenged by VI. So this is the context in which this whole discussion is happening. And the context is going to be pretty important, friends. And therefore, focus on the context. Now, there is a problem in the preliminary table. What is the preliminary table problem? The problem is that this table which DOT had filed in their modification applications. This modification application context was that when DOT saw the Supreme Court judgment was so harsh, they said that, look, we would like to request Supreme Court to give some relaxation to the operators on the modality of payments and expand the payment to 20 years. And this is the due, I think, that the operators have to pay. And this is the preliminary assessment subject to changes with the caveat which we have described below. So this is what DOT had said, right? Now, DOT's assessment was not final and DOT knew that it was not final. DOT knew that this assessment was supposed to be revised later. And therefore, it included that caveat. But Supreme Court disregarded that caveat and said that this assessment is final assessment, right? So the result is what? DOT was uncertain. Supreme Court still finalized and the operators got trapped because operators also did not get any opportunity to correct the errors that DOT committed in their assessment, the preliminary assessment. Now, the new DOT's demand of 9,450 crores, which they levied on Vodafone Idea in 2025, further reiterated the point of DOT that they thought that the preliminary assessment was not final, because Supreme Court imposed that preliminary assessment as final and disregarded the both DOT as well as the operator's point of view that there will be some changes. Now the point is that since DOT is relying on their caveat here, and therefore, this 9,450 crores which they had levied on Vodafone Idea as an additional demand was based on the point that they had a caveat in the judgment, right, in 2020, because this table have been extracted out and pasted in the 2020 judgment by Supreme Court. So DOT is saying that, Supreme Court actually had this in the judgment. So because I can change my demand because I thought that the demands were not final. So the fresh demand indicate that the earlier figures were not final. So DOT's point of view has been ratified by this new demand, but DOT relies on its own caveat to justify revision. But this triggers a very, very important point about justice and equality and fairness. If DOT can keep on revising their existing demand, which is the earlier, which was got finalized in Supreme Court in 2020, why not VI can seek parity and say that, look, I would also like to correct the errors. So therefore, it is extremely unreasonable for anybody to look at this case and say that, look, one party can revise, the other party can't revise. So Supreme Court, therefore, it raises a very important question before Supreme Court. Can the 2020 finality coexist with DOT's 2025 revision, right? Now, VI's September 2025 petitions. Now, what VI did, VI actually requested the Supreme Court to treat DOT's table as truly final. If they don't, then they have to open every AGR demand computation for reassessment. It is quite natural. Either you consider that as final or open everything for reassessment. And then what happened? They actually filed a modification application, which I showed you in this yesterday's press, money control headline, which says that Vodafone Idea filed an amendment petition to seek waiver of interest and penalties on AGR dues to Supreme Court, and then they did so on the existing petition by modifying its prayer. Now the point here is that why did they do so? That is what we are going to discuss as we move forward in this presentation. So it argues for correction of errors, duplication, and unfair penalty application. So what is VI's argument on interest penalty logic? It is important to understand that why they are seeking waiver for interest and penalties when they already had earlier attempted to seek waiver before Supreme Court and they failed, and now why they believe that they can be successful. The reason VI, the logic probably that the VI is applying in their revised modification, which is that they are revising the prayer using the modification, is that DOT's existing demand, which is the new demand of 9,450 crores, clearly ratifies the fact that the principle which was finalized in year 2020 on Supreme Court on the AGR dues on Vodafone Idea was not final. It was uncertain. Now, if it was uncertain, means neither DOT knew how much has to be paid, nor Vodafone Idea knew how much has to be paid. And on top of that, Vodafone Idea was winning the battle. If you see that in 2015 in TDSAT, saying that we were already in the mindset that we don't have to pay anything. Now suddenly the Supreme Court in 2019 decides that you have to make the payment, and therefore under this condition, when we were winning till 2015 and DOT's fresh petition clearly signifies the fact that the principles were not certain, right? They were uncertain. Then how can you levy interest and penalties on principles which were uncertain? Because it is not my fault. I did not know that we have to pay because I was winning till 2015, and the DOT's new demands clearly shows that they themselves were not certain what the principles would be. Then on what basis I should be charged interest and penalties? So they have quoted some cases in the Supreme Court which got decided that the petitioner should not be liable on interest and penalties on account of mistakes which have been committed by others, which was not under the control of the petitioner, right? So DOT's own revision undermines the certainty required for penalty accrual, right? Now here, the there is a question of natural justice and procedural asymmetry. DOT allowed, if DOT allowed to revise, VI blocked, it violates the equality before law, which we spoke about. Asymmetry breaches the principle of natural justice, and judicial dilemma is that what can they do? Now, Supreme Court, after having quashed all review petition, all corrective petition, VI's additional petition which they filed just some months before that, what they will do, how they will deal with the principle of fairness versus finality. So this is the Supreme Court dilemma. So Supreme Court can have various options. The option A is to uphold the 2020 principle as final and tell both DOT and VI that nothing doing, you cannot make any correction, this is final. Option B is to allow some correction. Now, if they allow some correction, it is going to be implicitly opening up the 2020 judgment, which has finalized the demand, in spite of the fact the table which was mentioned here was preliminary assessment with an understanding of DOT that these numbers are not final, which will be subject to change. But Supreme Court decided that, it should be final. Now, if they allow those changes to be made, then it is tantamounting to reopening the 2020 judgment. It will lead to institutional tension, precedent stability versus complete justice under Article 142. Now, there could be possible judicial pathways. Let me explain what kind of pathways there are possible. See, look, Supreme Court, currently, my understanding is the two-judge bench. Now, since the curative petition, review petition, everything has been quashed earlier, now if they have to open up this and say that, look, you can make corrections, or if they open up the issue of interest and penalties, which was decided in 2019 by Supreme Court, it is reopening of the full case from scratch, which means that you have to have an expanded bench and you have to do it under a certain unprecedented law or act of parliament, which I could not understand what it would be. Because VI's petition is not asking for review this time, nor it is a curative petition. It is, pointing to a inconsistency in the Supreme Court judgment of 2020 and 2019, which is quite apparent to everybody. Because if you look at, if there is a preliminary assessment, which DOT itself is saying it's a preliminary assessment, and Supreme Court saying nothing to it is final, and then Supreme Court, the DOT comes out with a request for revision, which clearly says that the principle itself was not final, then you impose penalties and interest on something which were not final, which operator knew what they have to pay, then this becomes a question about a prima facie error in the earlier judgment, which the Supreme Court had rejected earlier. Now, if the Supreme Court opens up this case, it would tantamount to a curative petition, almost like a curative petition. So if they change the nuances and make a judgment saying that, look, let's do the recalculation, let's waive the interest and penalty, you have to structurally change the bench. You cannot do it in a two bench. You have to have a higher bench than 3 judges. And then there has to be a fresh petition, something that it has to be a curative petition under the Parliament Act, under which the curative petition can be filed or some review petition can be filed. It has to be based on that. The current filing of VI is under Article 32, right? Where some fundamental rights have been violated and where you can go to the Supreme Court directly. So that can be done. Or it can be a subtle way of giving some relief to VI, saying that, look, we are not going to reopen the judgment. We are going to keep the principle same. Neither DOT nor VI is allowed to make any changes, but we will facilitate payment of the dues in a longer window period of time than 10 years, make it 20 years or 30 years. That I don't think will reopen the judgment. It is going to be a subtle way of reducing the pain on VI, as well as DOT will also enable DOT to handle this situation better. So this is the safest route. Denied broader relief, allow the limited correction or relaxed timeline. Article 122 may be invoked for minor procedural relief. The core 2019-2020 framework likely to stand but perceived as flawed. But we know that it is all fraud. Stakeholder implication, operators, if they do so, the Vodafone Idea can get some immediate relief, but long term, they have to pay the full principal, which will keep on compounding based on 8%. is not the question of revenue. It's the question of solving this current problem and making sure that the sector does not become a monopoly, right? It wants competition to continue. Judiciary, there is almost like a situation between a rock and a hard place. It has to balance finality with fairness under the scrutiny. Because the current petition clearly points to the fact that the whole demand was not final, which Supreme Court said it is final, right? Investor and consumer are confused. They don't know what is going on because this case is too complex and the nuances are very difficult to understand. So now we have to keep our eyes and ears open and see what's going to happen. As I said that if they open up the case and then all the past thing which got finalized, the correcting the assessment, make sure that the DOT whatever corrections they mistake that they have made, the operators are allowed to correct them or waive of interest and penalties. That would be the total review of the judgment, which I think is going to be extremely hard, extremely difficult. I believe that it is maybe possible to give relaxation on the window period of payment, which is now is on 31st March 2031. If you expand that beyond 20 years or maybe 30 years, relief can be granted because then DOT can give some moratorium, VI can become healthy, but the principle will keep on compounding. That is going to get hanging on the top of VI's head. But DOT can take more equities as and when VI actually is able to invest money from promoters and dilute the stake of DOT so that DOT can top up its stake to 49% and then reduce the total principal. But we have to see what is finally going to happen in the Supreme Court. I can't make any prediction right now. I have given you a very, very high level view about this understanding. Hope you have understood the complexity of this case. And thanks for listening till the end. And I'll come back with a new video and a new topic next time. Thank you very much, friends.